everyone. Yes, so I'll make a start. So my name is Josh. I'm currently working at FRU. So I'm not sure how much you know about FRU. So before I go into a bit more detail about how it would work if you wanted to volunteer, we essentially provide free advice and representation in social security tribunals and employment tribunals. And so, for example, for social security tribunals, we get the hearing date through from a referral agency, and it's about advising just for the hearing itself. Whereas for employment claims, you would advise on settlement, negotiations, up and until the hearing as well. So in terms of the way you would become a volunteer, essentially, I mean, I'm not sure, presumably you're all thinking about bar course, on bar course, or end of law degree. So to become a social security volunteer, you have to be at least in your final year of your LLB. And to become an employment volunteer, you have to have at least finished your qualifying law degree, so be that the GDL or the LLB. And alternatively, there is a dispensation we operate if you have particular experience within those areas, but generally speaking, that's the route. You then undertake a training day, which is held in London, often at some of the law schools, and then you take a test. So those are the basics about how you become a volunteer. And I think what I should say at this stage is if there are any questions, I think we'll come to the end after Alex's bit, and we'll just, anything you want clarification on or particularly interested in doing it through, let me know. So essentially what we run is a supervisory structure. So I'm an assistant legal officer. We have a full-time core staff who supervise you throughout the case. So I should probably say a bit more about myself, actually. I started as a volunteer. I've come through and I've worked as an assistant legal officer in the social security team. I'm now employment and I'm starting pupillage next year at 7 Bedford Row. So that's a bit of a background about that. In terms of whether or not, or why you would want to do one area of law as opposed to another, it really depends on timings as well as your interest. So when it comes to social security law, it might be that you have a 2-week period, a 3-week period that you can devote a particular amount of time to the case. And when it comes to that, you can sort of plan your time, and it's quite clear that you have a hearing date in 3 weeks. Employment law, for example, things can shift. So you might have a hearing in 6 months, or because of settlement or other adjournments, it's less defined time-wise. So it can be a case of you thinking, if I know that I want to do a certain case within a certain amount of time, that social security law might be your preference. So when I say social security law, I'm not sure how much you may or may not know about what that actually means. So the bread and butter of what we do for social security law is disability benefits appeals. So it's personal independence payment, things like employment support allowance. You may have heard, obviously, universal credit. So we have claimants who themselves cannot afford representation. They're unhappy with a decision made by the Secretary of State. They're saying, I either have been refused the benefit that I say I'm due, or I've been awarded a benefit that I say hasn't paid me enough. So those are the two ways in which we generally dispute those decisions. In terms of the process of advising in relation to those decisions, what you'd first do is you'd come to us and you'd sit with myself and my colleagues, and you say something called a ratification. So you sit with us and you go through the legal issues and the factual issues. And the idea is that you identify with us the key areas in which you can target the appeal, and also any evidential gaps, for example. So you come and talk to us about the law and the facts. We'll ask you a lot of questions, because it's obviously worth saying, once you're on board at FRU, we're ultimately responsible for you, and once you're instructed, it's very important that we give correct legal advice. So we are quite rigorous at that stage, but that's why it's a good platform for you to build the case, because you can come and ask us all of the stupid questions and we can go through it together and agree a plan of attack, if you like.
No such thing as a stupid question.
No, exactly. There's no such thing as a stupid question in the FRU office. It's very, I think I don't want to go into too much of the details, because I think if you come in an induction, we go through it all. But, we do always say there's no such thing as a stupid question. It's one of those things that's important you ask, even if you're unsure, because it's better that we have that at the ratification stage than when you're actually in front of the client or in front of the tribunal. So, you ratify, that means you can then approach the client. you approach the client and you offer representation, assuming they accept, which I can't remember the last time they didn't. I mean, obviously they're coming to us to find representation. Sometimes they may have found a friend or an advice agency in between. That means actually by the time we come to them, they've already got someone, but usually they say yes, and you arrange a conference. So I think Alex is going to talk more about the value of doing these things before you get into practice. But so a conference is your opportunity to give your advice to the client and to take instructions. So this is the first time you'll meet them, and the idea is that as a result of that conference, you've narrowed the issues, you've taken your instructions, and you say, right, for this hearing in 2 weeks, I know now the submissions I'm going to make. You then go on to written submissions, and this is your opportunity to hone your drafting skills. So you agree with us a final submission that you're going to put into the tribunal, and then that's going to form the basis of your submission. And then that carries you right through to the hearing itself. In Social Security hearings, obviously, and I'm saying all this in relation to that to begin with, essentially the hearing is based on the evidence of the client. So you will go in, and the tribunal should have your written submission, but it's very, very much based on what the client says. It's almost like an examination in chief, so I'm sure a lot of you know what that is. So, you can have times where, on the basis of your instructions, you think certain things are going to happen, and you have to manage a change in the hearing. So it's very good training in that respect, because the client might say something, and your eyes might sort of, or your ears might prick up and think, actually, that's not what you told me, or it's coming out in a different way, and you have to manage that and accept what that means for your case. So it's very good training for you to be thinking on your feet in that respect. And then you then go on and you have an opportunity to ask the client some questions. So that's the sort of basics of the Social Security process once you're instructed. Why do I think that Social Security might be something you're interested in? Well, it depends on the areas of law that you want to do. The good thing about Social Security law, aside from the fact you can, timing-wise, you can plan it out a little better, is that, if you're interested in public law, it is essentially public law. Dense statutory material, it follows political cycles, so invariably you'll find that there are lots of bits of law in lots of different places that aren't very clear. So if you're interested in the more technical side of deciphering exactly what these statutes mean in order to get the underlying entitlement, I think it's a good place to start. You also get quite a lot of witness handling, so even outside of the public law interest, because the Social Security cases, they always go to tribunal. You don't settle these things. You don't sort of agree with the Secretary of State, actually, okay, let's finalise the figure as you would in employment settlements. So that means you're guaranteed to get your day in court, or tribunal, I should say, and you will be able then to handle your witness, ask additional questions. So that obviously applies to an employment law interest, a criminal law interest. It's all good training, that's relevant to any area. In terms of the interesting cases you can do as you go on, we do criminal injuries compensation claims. So that's a very different scheme where you're actually dealing with obviously an underlying victim of a crime. So you can actually get exposed to that if you do more cases with us. And we also do some upper tribunal cases. So if you're a particularly experienced volunteer, that is the senior tribunal that you can appeal to from the first tier tribunal. So through FRU, if you give your time to it and you take on 4 or 5 cases, we'll get to know you, and then you'll have the opportunity to take on either the senior appeals or the more technical cases. And the reason I say that for Social Security is that you're more likely in Social Security to be able to accelerate through the different levels, whereas employment cases necessarily take a lot longer, and so it's more difficult to get the more complicated cases if you follow. So that's the background to the Social Security work. I think it's probably a good point if I take questions at that stage about the Social Security work, if there are any, and then move on to the employment law. I think that makes sense. So any questions about that? Yeah.
Well, thank you for this presentation. First of all, My question is, can you give an example of one of the interesting cases of when volunteers handled social security? What basically the facts of the case and how it was handled?
Well, I'll tell you, particularly one of mine that always sticks with me is a gentleman who had a split multiple personality disorder. Now, he was, and I think that's a good question, because it leads to sort of the nature of our clients. They are the most vulnerable, and a lot of them have a lot of mental health issues. So, client care and client handling is really paramount. And this is the prime example of that. It was a criminal injuries compensation claim. He had been assaulted whilst at a cash point, and he'd been knocked unconscious, and he'd broken his jaw and his collarbone in the fall. It was a very rough fall. Now, this is a client who was grieved and had a right to compensation, but as a result of his mental health conditions, he was very difficult to manage. And I think Alex has been in the office when actually he's calling up, as a result of his mental health condition. Sometimes he's thinking one thing and another time he's thinking another. And so reality is slightly skewed. And obviously, from the perspective of a representative who needs to get concrete instructions, it was very, very difficult, but very, very interesting, because you get the opportunity, in the hearing. I had to cross-examine a police officer because it was relevant to the underlying facts, as whether or not he cooperated with the police. Don't need to go into the details. I had to manage cross-examining the police officer, whilst my client wanted to examine him himself in a way that wasn't an agreed plan of attack for our case. And obviously I'd taken instructions, and it was very difficult but interesting to think about. I've got to think about the law, the questions I'm asking the police officer, and managing the client. So often that's the case, is that you're spinning a few plates in social security cases, particularly because of the underlying medical conditions. So it's particularly interesting. Hi there. Yep.
You talk about representing your clients at tribunals. Will you need to hire a audience for that, or was it just and it would be regular?
So that's a good question. Do you need higher rights of audience in order to, do you have to have finished the bar course and obviously be trained? The answer is no. These tribunals, generally speaking, are set up for unrepresented claimants anyway. The debate as to whether or not that's a valuable thing to do is for another day. But essentially, FRU has sort of a bespoke nature of insurance. So by acting for us, you're under our insurance. But the short answer is no. You don't have to have finished the bar course, and you don't have to have completed pupillage or in fact, a training contract and have got your higher rights. Is there another one over there?
Do you advocate against another person, like a barrister, or do you speak to the judge?
A good question. I mean, so as I was going to come on to the employment cases, invariably you will be up against a barrister on the other side, or someone from HR of said respondent. In social security law, the Secretary of State may send a presenting officer, and they're sort of internal legal advisors in the first tier tribunal, but it's not adversarial. It's inquisitorial in the social security tribunal, and what that means is really it's judge-led. You might go there and not have to say anything, and even the other side might not have to say anything. So it's about being, it's different in that sense. If you go to the upper tribunal, you will go against an instructed barrister, because the Secretary of State there thinks actually this is getting rather serious because it's going to appeal. So I think about 10 times this year I've gone against instructed counsel in the upper tribunal. In the employment tribunal, first tier, as is, you will go against some sort of legal representative. I mean, I think invariably they are represented. Sometimes you get an unrepresented respondent in employment tribunals, which presents a different challenge, but yes.
Depends on the size of the company.
Exactly. So any more sort of social security-esque questions? No? Okay, so employment claims. So I'm currently the legal officer, or assistant legal officer, I should say, for employment law. I'm not sure what sort of, is there anyone here with a particular employment law interest, or is the general, you're aware of that it's an area of law? Okay, so what I'll do is start from the bottom up. We deal with a range of claims, so something called unfair dismissal, where you say that, yes, I was dismissed by my employer, but there's something fundamentally unfair within that, and there is a body of law that tells you what ways a dismissal could be unfair. We deal with discrimination claims, so all sorts of, pregnancy discrimination, disability discrimination, and then underneath that also, harassment claims as well. And all sorts of unpaid wages claims. I won't go through them all in detail, but my point is that there's a lot of variety to the employment law work that we do. How is it different to the social security work? Well, I mean, in essence, as I said, the most simple difference is the timings are different. So you might take on a case, I think there was one I closed the other day that had been going for 2 years. So if you take on an employment tribunal case, I'm not saying you need to sort of write off the next 2 years, but it is a bigger commitment in the sense of, over a period of time, it may be adjourned, we may not settle, it may go to tribunal, lots of things can change. So the general difference is, if you want to get cases, and more than one, say before you're applying for pupillage next year, or thereafter, social security law is probably preferable because you'll be able to do more than one case. I mean, I think it's worth saying, I've been there, I was a volunteer, I applied for pupillage last year. A lot of people will do FRU, and a lot of people do the training and then don't take a case. But if you can do a few cases, it is noted at application sift and in interview, because obviously you're necessarily showing more commitment, and you've got more to talk about. You've just got more examples. So yes, so that's the nature of the employment tribunal work that we do. The reason it's fundamentally different, I mean, what you'll deal with is a respondent who may, invariably, if you have a strong claim, they don't want it to go to tribunal. So you'll get a lot of experience in settlement negotiations. Now, if you're interested in generally a civil practice, getting that negotiation experience will prove invaluable because it's the way things are. Very few cases go to hearing because if you have merit in your claim, you get a lawyer on the other side. They look at it, advise the respondent. You don't want this to go to tribunal. You're going to lose, and therefore, and obviously, the motivation for that is the cost risk. If you take this to the tribunal and you're going to lose, you're going to keep paying me my fees in the face of a loss. So, a lot of it settles. So, the only obviously downside of that is it might be that if you take on an employment tribunal case, you might not get your day in tribunal, if you like. It's important to be honest about that, but we look after the interests of the client. So whilst obviously we welcome the fact that volunteers want to advance their interests and progress, I had a volunteer the other day who said, yeah, I really want this to go to tribunal. I really want to cross-examine on this, that, and the other. And I had to say to him, I understand that, but it's in the interest of the client for us to settle this. So that's worth saying from the outset. Otherwise, I think employment tribunal work is a fascinating area of law. The underlying facts, I think a general overview of the cases we've got at the moment. We've got a bus driver who was running a red light and is suggesting that he should have run the red light. We've got people being accused of stealing things from work. We've got a very interesting and factually technical sexual harassment case. So that the nature of employment work means that the facts will vary more than they do for Social Security. So if you're looking for sort of that sort of civil work and the civil element of lots of different scenarios and employment scenarios, then that might be more of a preference for you. Social Security law is more just about I have this difficulty, this is how the law applies. So in that sense, they are different. Other than the settlement experience, going to tribunal, it's obviously adversarial. So as you're raising your question, it's more likely you'll be going up against another barrister, if not, someone experienced enough to make sure that you're on your mettle. In light of that, you'll be drafting witness statements. You'll be dealing with disclosure, and obviously thinking about examination in chief. I mean, I say that it's usually the evidence of the claimant's, on the basis of the claimant's witness statement, that will form the basis of the tribunal's decision. But you may be able to ask some additional questions in chief. Otherwise, it's about cross-examination at the hearing. So it's about you testing the respondents, witnesses, and it's about them testing your claimant's evidence in cross as well. So, I mean, those are the bare bones of the employment work. Is there any general questions about that before we move on? No? Okay. Well, I think at this stage I'll hand over to Alex to talk a bit about how FRU has worked in practice.
Hi. I do owe you a twofold apology. First of all, you notice my voice is going. I'm battling a cold. I'm really sorry about that. And second, I was a bit late. I was at the FRU stand talking to some of you people, very interesting conversations, and I'm not very good with my timekeeping, and so they had to come grab me to bring me here. Now, FRU, as Josh has said, is an invaluable service, and it serves two purposes for me. First and foremost, you are helping people. You are helping someone that is facing a very difficult situation in their life, both in the Social Security and employment tribunals, because they have lost money in both situations. In the employment tribunal, they've lost their jobs, most likely. Very few cases are still in employment and bring a case against the tribunal. And those are very difficult clients because they're going against their employers, so you know that they are going to be difficult. And this is very stressful for them, because until you pick up the phone and say, "Hi, I'm here to offer you representation," they think that they're going to be going at it by themselves. And once you get involved with the law and what it entails, you realize it's very complicated, both Social Security and employment. So that is very important. The job and the work that you're going to put in these cases is extremely important for them. But it's also extremely important for you. And we're not going to pretend that that is not a benefit of the free representation unit. We are run by volunteers just like yourselves. I'd say 80-90% are students. Because of the time commitments as well, there's not many people that are in full-time employment that can do free representation unit work. So no one is pretending that this will not benefit you as well as the people that you will be representing. And that is very important. Now, a bit about me. I started FRU work as a Social Security volunteer. I did a number of cases for Social Security, and then I'm now in my pupillage. I'm doing an 18-month pupillage. I did 6 months at the free representation unit as a secondment, and then I started my 12-month structured pupillage, which is going to end in March. So I'm basically on my feet doing my own cases. Now, the reason I bring that up is because I can attest to the fact that my experience at FRU has helped me in my practice now that I'm starting off as a barrister. Now, it's helped me in many ways. The two most important ways it's helped me is client handling and client care, and also my rapport and my relationship with my instructing solicitor. Now, client care, Josh has already alluded to that. At FRU, you have very difficult clients. You have clients that are going through a very difficult phase in their life, very sensitive. The matters you will be dealing with are very sensitive, and so you kind of have to learn to deal with that in the client conference. You're going to get clients that don't speak English very well. It's their second or third language. You're not going to have a translator because FRU doesn't have the resources, unfortunately. We might bring in a student that speaks that language, but that's about it. Or you might bring in a friend that speaks that language, but that's about it. So you learn various techniques about how to deal with your client. That will come in very handy when you're on your feet, and you can kind of look at someone and they know that this person cares about me because you've already grown that experience, you've already grown that skill. Now, because at FRU you're doing everything, you don't have an instructing solicitor, you are there meeting the client, you are there drafting their documents, you're drafting their witness statement, you're on the phone when some clients might be there calling you every day or twice a day. You have to field those calls. You have to be there. That is what an instructing solicitor does. Unless you do that work, you cannot appreciate how much work goes into this case before it reaches you in chambers wrapped in a beautiful pink ribbon. You just can't understand. You do have, an appreciation, you know how much work has gone into, but the actual relationship with the client is a very good insight to have. And once you're on the phone with your instructing solicitor and you say, I can only imagine how difficult this case has been for you because you've been through a similar case at FRU, that is the best relationship you can build with that solicitor. He's coming or she is coming back. Now, it also gives you other skills. It gives you the skill to say, I've been in a tribunal, I've done this before, I'm not fazed going into tribunal or court for the first time because I've done this. There's nothing that can happen in terms of the venue and the judge that I don't know. Now, there's plenty of things that can happen in your case that you have no idea where it's going to happen, but that is something that you cannot avoid. So, FRU has been an invaluable experience for me. I think it's been an invaluable experience for everyone that has done it and actually cared about it and put work into it and didn't just do it to have one case on their pupillage applications, which is okay, but you're not going to get the full value that you can out of it. Josh is another example. He got pupillage while working with FRU, while doing a number of cases, a number of difficult cases. And it makes a huge difference to be able to go into a pupillage interview and give actual real-world experience of work you've done in a tribunal, rather than saying, I've read this case, very interesting legal aspects, or I've observed this case. I've actually done it, and these are the difficulties that I faced, and this is how I overcame those difficulties. Yeah. It gives you great material for pupillage application and a pupillage interview as well.
Yeah, and I think it's worth thinking, presumably, what stage are we at here? Are you drafting applications? Is it next year? I'm just trying to get an idea of where the room is. So some are drafting, some are writing. Okay. But when you're applying, obviously they do have assessment criteria. The chambers publish, yeah. And I think the BSB also gives guidance on. I think that's correct. The things they're looking for in applicants for pupillage, which is generally speaking very similar to what they look for in tenants. And so what I'm getting at is there are clear ways in which FRU can sort of feed into examples concerning those competencies. So if you're dealing with multiple deadlines, for example, in a FRU case, you've got 2 witnesses to speak to. You've got directions for evidence being submitted next week. You're fielding calls from the respondent if it's an employment case. You're going to have concrete examples to talk about the sort of time management competency, and I mean they might call it something else, but you've got to think about what it is to be a barrister, obviously, and this goes generally for applications, and then think about how FRU can work into that. So obviously, you're going to have concrete examples if you've done a case or two of managing multiple deadlines. What does that require? That requires time management skills. Now, it's one thing sitting in a pupillage interview and saying, I have very good time management skills. It's another thing to say, there was a time in my FRU case where I had a deadline for a witness statement, and the day before that deadline, my witness changed a lot of the evidence. It changed the whole shape of the case. I had to put an application into the tribunal to amend that deadline, whilst also managing my client's emotions at a very difficult time, and I was also on the bar course at the time and had an exam the next week. It's much better and it's much more convincing to say, oh, I did all of this, rather than sort of describing. And I think what I'm getting at is, if you can get a case or two in, it really is going to give you these concrete examples, ethical problems as well. I mean,
ethical problems is a great one, because you're going to be faced with them at FRU quite a lot. An ethical problem is, for example, contradicting instructions. That's an ethical problem. What do I do? an ethical problem that we face quite a lot at FRU is my client wants to go down a route I don't want to go down because I don't think that either doesn't have a basis in law, or I don't think it's an ethical route to take, but that's what my client has to do. That's a huge ethical problem that you're going to face in practice as well if you go and practice as a barrister. So that's a concrete example itself. But also the other dreaded question is, why do you want to become a barrister? I remember hating that question.
Be ready for it as well, because it's a very obvious question, but they do ask it.
They do ask it. Everyone asks it. Everyone gives the same answer. Chambers despise that answer. But you're like, well, what do you mean, why do I want to become a barrister? Well, because I like advocacy and I like representing people. I like helping people. But it comes a long way, that answer comes a long way after you've actually done it in practice. And then you can say, I've done this, I want to become a barrister because, and then you can bring up an experience that you've dealt with.
Yeah.
And that's that moment, you knew this is what I want to do for the rest of my life.
And that's a good point, actually, because the other value, aside from explicit examples in your applications and for your interviews, through the FRU process, you might discover things about certain areas of law or of case management that you hate or love. You might do a FRU, and I think that's the other, I'm probably spoken about less, but it just, some people come and do it and they are training as a solicitor, they love the advocacy and then think, I'm going to jump ship to the bar. Sometimes it works the other way. When you're drafting submissions, you might think, I really like getting into the meat of a submission, being really technical, and you might think, okay, that's going to inform where I'm applying, maybe public sets or commercial chancery sets where it's more paper-based work. You might just think, I just want to get into tribunal. I love it. I love the cut and thrust. I love thinking on my feet and the intensity. I myself like both. And for me, that's why I'm going to hope to develop a civil practice, particularly in employment law. Employment is a good example of an area that gets you used to a bit of both. The technical areas is a very complicated body of law relating to each claim, but you also get a lot of advocacy, assuming it goes to hearing. So FRU is useful in terms of you just making your decisions and thinking, what do I like more about this? And
it's a safe environment to do that.
Yeah, exactly. Well. You can make mistakes within reason, and obviously we're there to help. And and I should say, I think generally speaking, particularly the first case, because we can sit here and we can talk about it. Outside of anything else, I can't stress enough how much I would say do a case, just at least one case, to know what it feels like before you're interviewing, applying, to act for someone, to be there for them. And to take it through to the end, and the feeling you'll get and the amount you'll learn about yourself in that will do wonders for any interviews that I'm sure that you'll go on to get.
Yeah, absolutely. Questions?
Is there any more questions? No? Yeah?
Regarding the procedure of representation, you might have mentioned it, but just to clarify one more time. So, during this work, does the volunteer's responsibility only extend to basically preparation of different documents and submitting those documents, or do they actually go to court and represent the client in front of a judge?
Yes, so if I didn't make that clear, yes. So you are when you're on a case, you're doing it all.
Right.
And unless for one reason or another we withdraw the claim on advice, you will be the person conferencing with the client, drafting submissions for the client, negotiating on behalf of the client, and advocating for the client at the hearing. And even after that, we may advise on appeal. So, I know there are lots of other great voluntary or great volunteering opportunities, but FRU is the only place, I think, I can say this, that allows you to do that. And that's not to brag, it's just, we're quite a unique organisation.
Yeah, and I think that comes from the fact that you are covered by FRU's insurance, because there's also Advocate, which was formerly known as the Bar Pro Bono unit, but that's only targeted to barristers and solicitors that have a practicing certificate. I think FRU is the only one that you actually go to court. Some citizens' advice, you might give some advice, but that's about
And that's not to say, don't do other things, but it's just,
Depends what experience you want.
Yeah, if you have the time, then make the most of it. I am interested to know what stage you're at, just to give more advice about, when to do cases. I mean, how many people are applying for pupillage this year, let's say? Okay, so not many, and the rest of you next year, or? I mean, I'm just thinking that obviously, if you're applying this year, I'd really advise doing as much as you can before Christmas. Now, that just goes for general work. I mean, we have our next training day. It will be February, I believe. So, obviously, necessarily,
Yes.
it might be that you won't be able to do cases if you're not trained yet for this round of applications. So, as to the rest of the room, I gather from that you're probably applying next year or thinking about applying next year. So, obviously, you have plenty of time. The only general point on that, as I'd advise outside of anything I've said, is that do it in, if you can get it before Christmas, assuming you're going to be on the bar course or on other courses, things do, heat up exam-wise, obviously. So leaving it quite late when you're, doing lots of exams. I had lots of friends on the bar course who were trying to do everything, in that February-March period just before the interviews. I definitely advise, the sooner the better, so you can, make your life more calm and less stressful.
Just wondered about the geographical spread of the work, where it takes place. So I live in Guildford, outside of London.
Right.
I also wondered if you could confirm an assumption I've got that any travel costs would be incurred.
Two good questions. We service London and the South East, so all of the tribunals will either. That does catch. I think we had one hearing in Southampton the other day. But generally speaking, it's central London, so it'll either be for employment London Central on Kingsway or Fox Court, which is just over there for the social security work. In terms of where you're located, obviously, if you live in Guildford, for example, we don't require, you could live in Manchester. It's about the contact hours. So your commitment to us is the amount of time you can be in the office. And it's probably worth saying at that stage, the work is office-based. We can't let you take the papers out of the office unless it's for the hearing or any conference. So necessarily that means, if you were in Guildford, possibly the commute might be a bit tricky. What I should say is the commute isn't something we could remunerate you for, but if you were going to a hearing that's quite far away, then we do have an expenses policy in that respect. But the main important thing to say is that, for a social security case, it might be 5 to 6 working days that you'd have to say, I can give through for the next 2 to 3 weeks and you'll be fine. Obviously, employment's different. Yeah. It'd be very difficult to say how much time that would require.
It's not that we don't let you take the papers out because we're difficult, but it's, you understand, very privileged information, very sensitive and confidential information that we don't allow you to. But we've all been there, that we can't go in the office. You can obviously just take some notes of the case, for example, no names, no identifying information, to do your research at home, for example, and work on that at home. Again, I stress, no identifying information. There's always ways to work around it. I find if you really want to do the work, there are ways that FRU is going to help you do the work. And, always come up or call and talk to a legal officer and say, these are the difficulties that I am facing. This is my day-to-day life. Commitments, family commitments, work commitments, university, school, whatever it is. FRU is there to help you as well, because you are very important to FRU. You do the cases, so FRU is there to help you. So never hesitate to pick up the phone and ask what FRU can do for you.
Yeah. And that's the other, just finally, the other benefits, aside from the papers being in the office, is it's similar, I think, to a chambers environment in that, it's quite dynamic, unless I'm in a meeting, Josh, I've really got this really big issue, or I've got this question. So obviously there is another benefit to being in the office, is just that we have materials there, and it's quite collaborative, that you get to know other volunteers, and as much as we can, we encourage, encourage interaction between cases. You can learn in lots of different ways. So, it's not just about being at hearing, and in that sense, there's lots, along the way that I think I'd recommend.
Yeah.
Of course.
You're speaking about ethical problems, not with volunteers who are not yet trained barristers.
are allowed to do the representations. Now, when they're faced with ethical problems, how do they address them?
So it's a good question. The question was, when volunteers as unqualified lawyers are addressing ethical problems, what are they supposed to do? I mean, it's probably good to give an example here. Only yesterday, I had a rep, a volunteer. He came out of the conference and he sat down. He said, "Josh, the case is over. I can't do it. We're going to have to. It's over. We're going to have to withdraw. There's a big problem." I said, "Okay, all right, let's calm down a second." The concern was, without going into the details, that in the client's witness statement, there's a way in which you can be dismissed, where you resign in response to a breach. There's another way, but that's all that matters for the purposes of this. Now, we needed for our case for it to be a case of us resigning, otherwise it doesn't really work factually. And obviously we take instructions, we can't tell the client what to say. And the client was sort of talking about it in a way that suggested at the time of this dismissal that actually she thought it was a redundancy, it was something else. And the rep came out and said, well, because she thought this at the time, obviously we can't now say that it was a resignation. And then through the process, it's sort of identifying the issues and actually saying, Mr. Volunteer, actually there were ways in which if you were confused at the time, but as the benefit of legal advice, you understand your position, it doesn't present a problem in terms of putting that evidence, but just being upfront about it. He says, yes, I know I was saying things at the time, but I didn't understand what a redundancy was, for example. So, in short, the way we deal with ethical problems along the way is by coming to us, and we'll have a chat about it. And this is why, I know I'm sort of ramming it home, but the only way you'll learn these things really is by doing, because you get that, you'll be at a conference and you'll get that sort of gut feeling, hang on, this doesn't feel right, I'm arguing this and he or she has just said that and I'm not sure. You'll only get that sort of tangible experience if you do a case. And again, in an interview, that rep is now going to have a moment, I thought the case was gone, this is what happened, this is what I did to address it, and this is what I do next time.
Yeah, it teaches you to listen as well, because it's very easy to go into a conference with all your notes prepped and kind of just go through your notes. Your client is saying something, but you're not really listening to them, and then suddenly you're like, oh my God, what did the client just say? And the client's left because the conference has ended. So it's very good experience with that, and it's also good to kind of pace yourself. You listen to the client and then you're like, maybe I need to take a step back here. This doesn't sound right. What do I do? And most ethical issues I have faced, to answer your question as well, has been applying common sense. Now, this doesn't feel right. My common sense tells me that this is what should be done here. And don't forget that when you're facing some ethical dilemmas with your client, it could be that you're facing them with your respondent as well. So it teaches you that skill. So I had a client that she didn't want to disclose her pay slips to the respondent. And that came into mitigation. How much work have you done since we fired you? Because if you win, then we need to adjust the amount we pay you. Now, my client didn't want to disclose the pay slips because she didn't like the respondent, hated the company, didn't want to give them the satisfaction that she's done work. And as far as she's concerned, why should I disclose my pay slips to them? Now, the respondent was accusing me of not disclosing the documents, that I did have the documents in my possession, and I was being unethical not disclosing them. And of course, you can't say, well, it's my client that's not disclosing them to me, so I can't disclose them to you, because you owe that duty to the client. But you also can't say to the respondent, well, no, that's not true, or it is true. So that's a very fine line that you have to tread while you're dealing with your own client and solving that ethical question and dilemma. Now, what we end up, of course, we disclose them at the end, but it kind of teaches you how to deal with clients that can be a bit difficult. They don't mean to be difficult, but also having the respondent on the other side blaming you because you're the face of the claimant, of course. So, yeah, apply common sense and talk to one of us, I think.
I'm going to have to stop you there.
Yeah.
I've just started to overrun. Just thank you very much to our speakers from the three.
Thank you for having us.